Hi, it's Victoria Mavis from 2-Minute Tidbit, and I'm here with my friend Vicki. And hi, Vicki.
Hi.
Good to see you.
Good to see you again.
And thank you for enjoying ice cream with me today. It's such a great treat.
Oh, thanks.
I think you still have a question about terminating your employee. So let's talk about that.
I do. I really wanted to get back to the point when I should call an attorney.
Oh.
Just in case the accountant that I'm terminating tends to be a little bit litigious.
Got it. So here's the thing about that I always advise all clients is one, you just need to recognize when you call them. If she goes away and you never hear from her, you don't need to call an attorney. You know, one thing you want to be careful of is that you save all your documentation. You save a copy of all her warning forms. You save a copy of your write-up of all what she did or didn't do. You have a copy of her termination letter. Because if she does call an attorney, you're going to want to be able to prove what you did and why you did it. So here's what a lot of employers don't understand. I can never prevent somebody from calling an attorney. And just because I can't take that right away from them, that is their right to call an attorney, as well as it's their right to, through the EEOC, put a discrimination charge against me. I can't prevent that. But that doesn't necessarily mean because they do it, they're going to win. And so if all of a sudden you get a letter from her, and a client of mine got one the other day that said, unfortunately, his brother was suing him for firing him from the business. You know, and it was just an attorney saying, I'm representing, your brother, and here it is. You know, we want $50,000 to settle. And I said, to my friend and my client, I said, I pick up the phone now, and now is the time you call your attorney. Now, there could have been some things that happened in between time, but you just got to recognize you can never take that right away. The other thing, not in every case, but some situations require an employee to file their complaint against you through the EEOC first before they can get an attorney involved. So again, that's hard to just do in our 2-minute tidbit to talk all about that, but it's a basis of employment at will, which says that you as an employer have the right to let somebody go for any reason, as well as they have the right to leave you for any reason, as long as it's not discriminatory, meaning everything you hear, the race, the sex, the age, everything that's covered under the Civil Rights Act. And so that when you hear the term employment at will, that's what it's referring to. It's a legal right that everybody has, and almost every state's an employment at will. There's, in fact, I'll give you a link to another YouTube video that does a really good job of explaining employment at will from an attorney's perspective. So for now, what I do is be clean on your paperwork, be consistent, and just monitor what's going on, and be generous when you go to fire.
And it sounds like whether or not the time comes when I should call an attorney, it always helps to be prepared.
Absolutely. Preparation
Excellent.
Is the key in any of this, turning out in a way that benefits you in your business.
As always, thank you, Victoria.
Yeah, you're welcome. Thank you. Thank you for coming in. And we've got a couple more minutes. We're going to just enjoy our ice cream. Lewisburg Freeze Creamery and Deli, thank you so much for our ice cream. You're great.